It's Wednesday afternoon and time for us to turn our attention to legal matters. This is part of our commitment to putting Southeast Texas first. So let's ask the judge and get answers to some of your questions. We are joined by Judge Gordon Freeze from the 317th Civil District Court here in Jefferson County. Judge, how are things?
I'm good. Good rainy afternoon to you, Jordan.
Yeah, I know. That was quite the downpour. First question from a viewer who says, my son took a plea deal he shouldn't have taken. I know he didn't do it, and I have evidence of my own and witnesses. His lawyer talked him into the deal when he was scared. Is there something I can do to help my son clear his name?
Okay, to answer this one, I'm going to make a couple of assumptions. I'm going to assume, one, that her son is an adult, and two, that she wasn't involved in the case. With that said, I really don't know that there's necessarily anything she can do or he can do. They were not the client. They didn't take the plea deal. If their son believes that they were mistreated or misguided by their lawyer, they would need to take the initiative and take some action. However, even if that happened, I don't know that there's much ground to stand on here, unfortunately.
Yeah.
Whenever a judge takes a plea, they routinely ask if the client is pleading freely and voluntarily, and because they're actually guilty. And again, assuming he's an adult, I think you just got to let him handle this as an adult and stand on his own 2 feet.
All right, Judge. This second question, a person wrote in saying, my ex and I lived together in Texas over 10 years, shared finances. We referred to each other as spouse, but we never had the ceremony, never did the paperwork. Now they're claiming we're common law. Can I fight this? Sounds like they've since separated.
You know, congratulations. You may very well be married under the statutes in the state of Texas with an informal marriage as defined by the family code. By referring to each other as spouses, they have held themselves out as spouses or husband and wife in a manner that can lead to there being an informal marriage. That, along with sharing finances, cohabitating, filing taxes, is probably enough to prove that they may have been married. I would suggest that they speak with a lawyer to determine what arguments they might have and also what other unintended consequences there could be if they no longer want to be informally married.
All right. Final question here. This person says, my mother died last year in Texas, but she owned property in another state. Will she also need to open probate there?
You know, the short answer is probably. I think subject to the laws of the state where that property, and again, I'm assuming it's real property is, they would probably need to open some type of ancillary probate proceedings after they probate the will here. And this person, again, assuming they're going to be the executor of the will, they would need to go to that state, file these, register this order here, and then file an ancillary proceeding to take care of that home or whatever that property is. And again, where I'm saying it depends, and probably every state has different, laws on as far as probate and intestacy, but more than likely they will, but they're going to need to do the Texas proceedings first.
All right, Judge, we'll have to leave it there. We really appreciate your time.
All right, thank you, Jordan.
Judge Gordon Freeze with us from the courthouse. If you've got questions for the judge, head online, 12newsnow.com/askthejudge.